Member of the Parliament, Mr. S. Prabhakaran, Vice Chairman, Bar Council of India, Mr. Apur Kumar Sharma, Chairman, Executive Committee, Bar Council of India, Mr. Ved Prakash Sharma, Co-Chairman, Bar Council of India, respected delegates and representatives of the State Bar Council, esteemed members of the Bar, including senior advocates, I'm really overwhelmed with the welcome and greetings. Thank you so much for your kind words, Mr. Justice Rishikesh Roy, Mr. Justice Vibhu Bakru, Mr. Venkatramanni, Manan Kumar Mishra, S. Prabhakaran, and Ved Prakash Sharma. It's been a long journey since I began practice in 1983. And then as a judge in the Delhi High Court in 2005, followed by my journey to the Supreme Court in 2019. In a way, then, when we look upon judiciary, how do we view the judiciary? What does the word judiciary mean? When we envision the judiciary, our minds are often gravitated towards image of judges in robes, presiding over courtrooms, delivering judgments that shape our lives of individuals and society. In the minds of many, judges are singular face of justice. Judges alone bear the respect and responsibility of ensuring justice is served. But this narrative is incomplete, if not fundamentally flawed. Judges are indeed a vital part of the judiciary, perhaps the most visible part. Judiciary is incomplete without advocates. Judiciary is in fact a collective name for the bench and the bar, where the judges are stakeholders in pursuit of justice. Advocates are part and parcel, playing the crucial and significant role in the judiciary. Judiciary is not 10,000-20,000 strong, consisting of the judges. Judiciary is equally fortified and represented by the advocates force, consisting of, now I am told, about 27 lakh advocates. There are 5 or 6 remarkable ways in which the lawyers contribute to the judiciary. First, the rule of law is arguably the most basic requirement for any civilized society. Disputes are natural, so is their resolution. In ensuring the rule of law, you are the first face for anyone wanting or need of justice. You connect the citizens to the judges. You provide access to justice and judiciary. In other words, you are somewhat like the members of the legislature, the face, the mouthpiece, and spokesperson representing any and everyone in need of justice. You depict and portray the judiciary. Secondly, the lawyers, through their wisdom, not only assist the courts, but fundamentally shape the law of the land. You give meaning to the words in the statute. To quote the words of Justice H.R. Khanna, judges are more often shine in reflected glory. There are a good number of judgments which reveal not so much about the erudition of the judge as of the counsel who have argued the case. Thirdly, we the judges come from and go back to the bar. In a way, we belong to the bar. The better the bar, the better are the judges. Fourthly, lawyers voice diverse perspective and grievances. This not only makes the judiciary, but also our democracy vibrant. It is this plurality of voices in the courtrooms that play out through the deliberative process between a lawyer and a judge. to share personal observations. Lawyers come from diverse backgrounds in the Supreme Court. This diversity and polyness contributes immensely to the court's advantage. Fifthly, disputes are always deeply rooted in complex socio-economic contexts which demand a thorough analysis and understanding of factual background. This is the subjective element of justice. Hence, complete justice demands that adjudication should not be restricted or an isolated academic exercise. Rather, it is through the lawyers that the bench grasps the nuances of the lived experiences of the parties. It is often thus said, with jurisprudence, lawyers most do it, but it is fact that they have all to do. With the sound views, their influence in many ways will be said to be incalculable. Ultimately, what is the judge's greatest concern? It is the apprehension of rendering a decision will fall short of doing justice. Thus, collaboration between the bench and the bar is crucial in upholding the spirit of justice. For these reasons, a well-prepared lawyer is an asset to the judiciary. It also means it is a tall burden cast on all of you, an oath no less than that of a judge, inherent in your role as an officer of a court. Lastly, when we refer to lawyers and judges as two wheels of the judiciary, we highlight their role in checking and balancing each other. It reflects the inbuilt checks within the judiciary. Advocate checks our actions, and we adjudicate, ensuring each fulfills their designated role. The accountability check must not be mistaken as confrontation. We are both accountable to the public as the judiciary. For example, addressing the issue of adjournments is not a critique of the judges or advocates. It speaks to the judiciary's commitment to improve as a whole. Though unelected, we are always accountable to the public and under their constant scrutiny. Today, we must acknowledge the challenges that continue to hinder functioning of the bench, the bar, and the judiciary. While India boasts of world's largest lawyer communities in number, this numerical strength has not guaranteed quality and speedy access to justice. Backlog, delay, ease, and cost of access are systematic problems. If left unaddressed, they will threaten to undermine the vision of rule of law and shall stall the progress and development we all need. Fear of approaching the courts for justice must be dispelled. Friends, one of the effective ways to enhance accessibility and also assist the courts in efficient justice delivery system is through embracing resolution-oriented approach, particularly alternate dispute resolution methods. By promoting mediation and pre-litigation negotiations, prolonged legal battles, lawyers can help reduce the case backlog while offering clients more efficient, cost-effective solutions. This is visible. Today, lawyers proactively guide clients towards dialogue-based resolutions, explaining the trade-offs between litigation and mediation. They have evolved into skilled negotiators both inside and outside courtrooms, with the Bar Council particularly developing guidelines for pre-litigation strategies. Inspiration from this can be found in the Commercial Courts Act of 2015. Section 12A of the Act mandates mediation before filing of a lawsuit in commercial disputes. Additionally, the legal profession must embrace self-evaluation through initiatives promoted by the Bar Council and various associations. Lawyers must particularly assess how efficiently they manage cases, from strategies for quick disposal to timeline adherences as being mandated under the new laws. Today, we are witnessing a concerning trend where bright young legal minds are increasingly gravitating towards corporate law firm or leaving law altogether to pursue managerial roles. While corporate practice or house roles certainly come with their own merit, we must ask ourselves, are we the torchbearers of the legal community somehow failing to guide the young lawyers towards public interest work? Who will represent the common citizens in future? The exodus of young talent from litigation practice is not merely about personal choice. Rather, it is symptomatic of the structural issues such as meager financial and social security in the profession, especially for the first generation lawyers. To attract community of young lawyers dedicated to serving the public, we must work towards making a profession a more conducive space, address entry-level barriers, and promote support. One step towards addressing these challenges is creating a minimum remuneration standard for young advocates in first few years of their practice. I applaud the recent recommendation of the Bar Council of India for payment of minimum stipend or remuneration to young lawyers in urban and rural areas. This would hopefully give early exposures to the young lawyers in the courtroom practice so that they can make informed career choices rather than defaulting towards corporate path. Today, district courts are adorned by erudite judges, and these courts have become bastions of robust courtroom practice. But more importantly, given the fact that the district courts have a direct connect with the grassroots and are the court of first and in most cases the last resort, the bar must be able to completely represent their concerns and aid the court in doing complete justice to the parties. In the 21st century, the practice of law has undergone a dramatic change. With rapid evolution of legal markets, the areas of law have become highly specialized, moving far beyond the traditional buckets of civil, criminal, and public law. Now we have the niche fields in insolvency, intellectual property rights, arbitration, which have carved out sufficient space for the legal profession. Even in criminal and public law, complex cases involving narcotics, forensic science, and even balance between fundamental rights such as privacy and freedom of speech challenge lawyers' understanding. This intricate landscape calls for young lawyers to embrace domain specialization and cultivate expertise in these domains. The role of the bar councils and bar associations is as a driving force in these initiatives cannot be stressed enough. Recent judgment of this court delineates the responsibilities and powers of the Bar Council. It authorizes Bar Council to conduct the All India Bar examination at a pre-enrollment stage. It also reflects upon the role of the Bar Council as stated and prescribed by Section 5 of the Advocates Act. While the Bar Council is not entrusted with direct and absolute control of the legal education, being the apex professional body of the advocates, it carries the duty of managing high standards of legal profession and equipping those who seek entry into that profession. Consequently, the Bar Council of India must work towards bringing accessibility and sustainability gap permeating in our profession. The Council must take up the baton of ensuring a conducive and sustainable work conditions. As I come to the end of my address, I'd like to implore to reflect on the path which lies ahead. As I stand before you, emboldened, for today our courts are filled with some of the brightest and brilliant young minds. Martin Luther King Jr. once observed, "Everyone can be great because everyone can serve." As we walk out from here, let us remember that the service we render unto others lies the true measure of our triumph. Together, we can raise the bar, the bench, and the judiciary. Thank you and Jai Hind.
Thank you very much, sir. Before I request Mr. Apurva Sharma to propose the vote of thanks,